Welcome back, everyone. We're going to continue this morning in our second hour. It's the Standing Committee on Public Safety and National Security. And this morning we are commencing our study of Bill C-51, an act to amend the Witness Protection Program Act and to make consequential amendments to another act. Our first witness is the Honourable Vic Taves, Minister of Public Safety, National Security. Accompanying the Minister from Public Safety Canada is Trevor Bussing, Director General of Law Enforcement and Border Strategies Division, and from the Royal Canadian Mounted Police, Assistant Commissioner Todd Shane, Federal and International Operations. And again, Minister, we thank you for coming to committee. You've appeared here a number of times at our requests. Thank you for your availability this morning. We would invite you to make your opening statements in regards to this new bill that this committee will be looking into, and we welcome your comments.
Thank you, Mr. Chair. Thank you, committee members, for the invitation to appear before this committee to assist you with your deliberations on Bill C-51, the Safer Witnesses Act. As indicated, I have senior officials with me from both public safety and from the RCMP. The Safer Witnesses Act will help to strengthen the current federal witness protection program, a program which is often vital to effectively combating crime and, in particular, organized crime. Bill C-51 will first and foremost improve the interaction of the federal witness protection plan with provincial witness protection programs. At the moment, someone in a provincial program obtains federal documents required for a secure identity change only if he or she is temporarily admitted into the federal program. This process can result in delays in obtaining a new identity. Bill C-51 proposes to remedy this situation by establishing a process whereby the provincial programs can become designated witness protection programs. A province would request this designation from the Minister of Public Safety, at which time the provincial authority would provide assurances of the program's capacity to protect both its witnesses and its information. Once a program is designated and upon the request of the program, the RCMP would be obliged to help in obtaining federal identity documents for a provincial witness requiring a secure identity change without any need for him or her to be temporarily admitted into the federal program. This new system will cut red tape and make the process more efficient and indeed more secure. Currently, each law enforcement agency submits its request for federal identity change documents to the RCMP. Under the designation regime proposed by the bill, the provincial official from a designated provincial witness protection program would request federal documents on behalf of the law enforcement agencies, and this process would limit the number of individuals involved in the process. The bill would also enhance the security of witness protection regimes in Canada by both enhancing and broadening the current prohibitions against the disclosure of information. The current Federal Witness Protection Program Act prohibits the disclosure of information about individuals within the program. Section 11 of the current Act says that no person shall knowingly disclose, directly or indirectly, information about the location or a change of identity of a protectee or former protectee. Bill C-51 will strengthen this prohibition in a number of very important ways. It will not only prohibit the disclosure of information about people who are in the federal program, it will also prohibit the disclosure of sensitive information about how the program itself operates, as well as about those individuals and frontline officers who actually provide or assist in providing protection for the witnesses. So it's those who are also administering and working with the protectee who are also protected now. This legislation, in particular this portion, has received very strong report. Tom Stamatakis, the President of the Canadian Police Association, has stated that the Canadian Police Association appreciates the steps being taken by the Government of Canada to protect frontline officers. He went on to say, on behalf of the over 50,000 law enforcement personnel that we represent across Canada, we ask that Parliament quickly move to adopt this bill. Mr. Chair, I can't say I disagree. Both of the prohibitions I mentioned earlier will also extend to designated provincial programs, that is, disclosure of information about witnesses, people who provide protection, and sensitive information about the programs themselves will be prohibited. Such prohibitions against the disclosure of information currently exist only within the legislation of the particular provincial jurisdiction, and so they don't apply across jurisdictions. Bill C-51 will also clarify the prohibition with respect to what and how information is being disclosed. As I have mentioned, Section 11 of the current Act contains the phrase, "No person shall knowingly disclose directly or indirectly information about the location or a change of identity of a protectee or former protectee." The phrase directly or indirectly was considered to be unclear. The bill proposes amendments to ensure that the prohibitions will clearly apply to cases where a person discloses information in a range of ways. Some examples include by telling someone what a protected person's name is, excuse me, and by telling someone where a protected person lives. Bill C-51 will prohibit all of the above disclosures by specifying that no one shall disclose any information, either directly or indirectly, that reveals the location or change of identity of a protected person, or the information from which the location or change of identity may be inferred. Among other improvements, Bill C-51 will expand referrals for admissions to the Federal Witness Protection Program to sources assisting federal security, national defense, or public safety organizations such as National Defense and the CSIS. By extending referrals to this category of witnesses, we are also addressing one of the commitments under the Government of Canada's Air India Inquiry Action Plan released in 2010. The current Federal Witness Protection Program has served the criminal justice system well. Today, there are approximately 800 individuals under the protection of this program. In 2011-2012 alone, the RCMP considered a total of 108 cases for admission into the Federal Witness Protection Program. 30 protectees were admitted to the program, of which 27 were granted a secure name change. The number of admissions fluctuates from year to year depending upon factors such as the number of cases being investigated or the number of people in a witness's family. During this same time, the RCMP also provided assistance to other Canadian law enforcement agencies as provided for under the existing Witness Protection Program Act. The fact that the Federal Witness Protection Program is serving the criminal justice system well does not mean there is no room for improvement. The Witness Protection Program Act has not been substantially changed since 1996, despite the increasingly sophisticated, evolving, and global nature of organized crime. Ongoing consultations with provincial and territorial stakeholders have also helped to highlight some areas where stronger provisions are needed, including those that I have mentioned today. I must mention that this legislation has been well received by police chiefs, frontline officers, and the provinces. Mr. Chair, before I close, I am aware of some concerns with regard to the need for funding to accommodate the expansion of organizations that may refer witnesses for consideration of admission into the program, and I want to take a moment to address those concerns. It is important to note that it is not anticipated that there would be any need for additional funding to accommodate this change. The program is currently funded by the RCMP from existing operational resources, and that will remain the same under Bill C-51. I would like to point out that there are 7 criteria which the RCMP uses to assess whether to place an individual into the program. The cost of the protection is only one consideration. The Commissioner of the RCMP is required by statute to consider the risk to the witnesses, the danger to the community if the person were to be admitted into the program, the nature of the inquiry and the importance of the witness in the matter, the value of the information or evidence to be given by the witness, the likelihood the witness can adjust to the program, the cost of maintaining a witness in the program, alternate methods of protection, and other factors deemed by the Commissioner to be relevant. The RCMP will continue to be required to take each of these factors into consideration under Bill C-51. I've also references to the fact that many people were applying to get into the program, but only 30 were admitted last year. I'd like to point out that there is no application process. The law enforcement agencies and international courts and tribunals refer individuals to the RCMP for consideration of admission, and each case is reviewed based on the 7 criteria I have mentioned. The truth is that very few people, if any, actually want or apply to be admitted into the witness protection program. It is a tool of last resort to keep them safe in exchange for their testimony. It imposes significant restrictions on their movements, lifestyle, and associations. That said, the Witness Protection Program is a vitally important tool in our ongoing efforts to combat organized crime groups. The bill addresses the need for modernization as well as enhanced information protection and integration with provincial programs. The bill introduces reforms to the present witness protection environment that will build on our collective efforts to battle organized crime as well as terrorist organizations, and that way helps all of us to continue to build safer streets and communities for everyone. I ask that both opposition parties work with us to move forward this important piece of legislation. Thank you very much.
Thank you very much, Mr. Minister, and I know there will be some very good questions coming out of that. We'll begin with Ms. Bergen, please.
Thank you very much, Mr. Chair. Thank you, Minister, for being here, Assistant Commissioner, and your officials, Minister. I want to just get right into the issue of cost, because what we found with the opposition, and it's kind of interesting, there's a bit of a pattern. In this particular bill, they support the bill, the NDP support the bill, and yet they were constantly talking about the fact that they think we need to put more money into the program. Interestingly enough, with C-42, for example, they don't support the bill, but they want more money for it. And even when the Commissioner said we don't need more money, the independent chair of the Complaints Commission said we don't need more money. The NDP just want to keep throwing more money where it's actually not needed. Can you please tell us very clearly, or if the Assistant Commissioner could tell us, is there more money required when and if C-51 passes?
Thank you, and I'll let the Assistant Commissioner follow. I'll just make a couple of comments. In my briefings with the RCMP, they've advised me very clearly that they have the resources to administer the Witness Protection Program. In fact, what this program really does is streamline the process and should in many ways perhaps even save some administrative costs in that respect. The prohibitions are simply a broader way of protecting individuals in law without requiring any additional resources. But if there are additional resources that are needed to administer the program, the RCMP advises me that they have the capacity to manage within the existing budget. I want to make clear that it's not when we talk about 107 witnesses that have been considered by the program in any one year. It's not that there's 107 who want to join the program. It's simply a consideration based on the criteria that it might be advisable for these individuals to be in the witness protection program. And as indicated, there are some substantive limitations on their lifestyle and where they live. So many people simply do not want to take that route, and there are other ways of protecting these individuals. Perhaps the Assistant Commissioner can add to my comments.
Mr. Minister, Mr. Chair, what I could add is, as the Minister has stated, with the changes that this bill brings about, the RCMP is comfortable that we have the resources within our existing resources today to run an effective witness protection program.
Thank you. There also, again, during the opposition's comments on this bill, and I could almost quote verbatim, they said several times, 108 applied, only 30 were accepted. We can only assume that's because there were not enough resources. And my challenge to them was it's probably not a good thing to assume anything. Was their assumption correct? Or can you please re-explain that for everyone here?
Well, I'll let the Assistant Commissioner answer, but it's not that there's 108 who require protection, but only 27 or so get it. That's simply false. If that's the impression being left by anyone, that is a false impression. Those who need protection receive the protection if the program is the appropriate one for them to receive that protection in.
That's correct. It's not a question of resources. It's a question of the assessment that's done. And once the assessment is completed, during the assessment process, the person may decide that they do not want to enter into the program, or they don't want to proceed on the route that they're on, or we may assess that they're not suitable for the program. So the assessment is done, but the person is not necessarily entered into the witness protection program.
How much time do I have, Chair?
3 minutes.
Good, thank you. Can you also speak to those 7 criteria? And my understanding is it's actually in the Act, so not in this legislation, but in the Act as it exists. 7 criteria are laid out, one of those being costs, which I think, again, there's been some confusion. I think on the RCMP website it refers to sometimes municipalities or provinces don't end up or actually carrying through because of costs. And again, there seemed to be a misunderstanding that was just because there's not enough money, they can't protect people. Whereas it seems to me that it's more within the criteria, looking at the cost versus is it actually going to be a benefit and will it be able to protect the individual. So can you speak to the criteria and, again, very specifically the cost? It's really important. We have the support of the opposition. Cost is the only thing they're talking about. I think we need to be really clear on where the costs are and if there is any deficiencies.
As you stated, the criteria are under Section 7 of the Act, and it's one of the considerations. But I can say that at the end of the day, the Witness Protection Program reports into me, and I'm the one that signs in on the admissions or the determinations, and it's one of the factors that's considered. But since my time in the chair, never have I denied an entry because of costs.
And when you say cost, it's literally how much is it going to cost to protect this person, to change this person's identity? It's always
a consideration we have. As part of the assessment, is what type of protection are we going to have to afford this particular individual? And normally, it's based upon the type of organization or the type of situation that the person finds themselves in, and the type of protection that must be afforded.
Are we expecting with the changes in this bill that there will be a huge flood of new witnesses that will need to be protected?
No.
Thank you very much. That's all my question.
I think just on that point,
yeah.
The criteria aren't changing. What we're doing is streamlining the program in respect of the interaction with the provincial program. So that's the and of course the additional prohibitions against disclosure of certain types of information.
Yeah, again, the opposition in their comments, because there was going to be now, we would take applicants from national defense and a few other areas, public safety, that there now would be a great flood of new witnesses that would need to be protected. But that's not the expectation, because we're opening it up as per the Area Indian Inquiry recommendations.
Thank you very much, Ms. Bergen. Thank you, Minister. We'll now move to Mr. Garrison, please. You have 7 minutes in the first round.
Thank you very much, Mr. Chair, and thanks to the Minister and the officials for being here today. We on this side of the House are very glad to see C-51 before the committee, and also, of course, we have committed to expediting its passage through the House. We believe it's important legislation. It's something we've been interested in since the time of the Air India inquiry, where the inability to protect witnesses in national security matters became very obvious. We also are very glad to see the expanded definition so that it might be able to be used in street gang protection of witnesses to combat street gangs. We know that's been a very big concern of municipal police forces. The coordination and assistance provincial program is very positive, and I think one that's not received enough public attention is the additional protections to those working in the program, because we do know that organized crime, in the attempt to break the witness protection program, has a temptation to pick on those who administer the program. So we think that's a very important provision for protecting the police who work in this program. the parliamentary secretary has read some of my notes this morning, obviously, and used them for her presentation. But we do think that, and we have heard from municipal police forces, that there will be some additional demand on the program if they're going to use the program to combat street gangs, which they weren't able to do before. And we had one very specific instance of Chief McGrogan from Medicine Hat, who appeared before the committee here and expressed his concern about costs for municipalities of witness protection programs. So I do have some personal experience with this as a police board member and as a city councillor, and I'm going to save the minister some time because he usually responds to me by talking about my record as a police board member and a councillor. So I'm just going to save him a little time in his response on this by pointing out that when I served on the police board and as a councillor, each and every year the police received additional resources, and each and every year I supported the vote and voted for additional resources for the police. So I don't know where his confusion about my record comes from, because it's very clear public record. So I'll save him time this morning from doing that response. But I really do want to come back to this. The minister said no additional resources for the RCMP, and we take it in good faith the RCMP can manage the program. But our question about resources is really at the municipal level, where municipalities face downloading and policing costs of all kinds, and certainly, again, the parliamentary secretary made reference to the statement on the RCMP website that there sometimes is a reluctance of municipal police forces to use the witness protection program because if it's a federal prosecution, they will be billed back the full costs. So I would just, I guess, like to have your comments on that in terms of resources.
Well, actually, I wasn't going to mention your record. I have the quotes if you want them, but I thought we were starting off on such a good footing today. All the nice things that you're saying that I thought, why get into a cat fight on that kind of stuff, you know? So I appreciate the fact that the opposition is supporting this bill in principle, and I respect the fact that you have questions that you need to ask. First of all, I am a little confused about the issue that street gangs are now included. In my opinion, the nature of the crime and who commits it is irrelevant. If a witness needs protection, that's the only criteria. So we don't make a distinction about whether somebody is a street gang or whether they're old mafia or other types of organized crime who are going against witnesses. The criteria that are considered are the ones laid out in the statute, and I don't believe that there's any restriction on the type of criminal that is causing these individuals threats. So somebody must be mistaken. Maybe just to get the RCMP, if I'm mistaken in that respect, please correct me.
No, myself as well. We look at the threat assessment to the potential, to the witness or the person involved, and it can be the crime can be what the crime would be.
Certainly, in looking at C-51, it does change the definition and broaden the definition of who can be included. So I guess it'd be good news then, because where we had that impression was from talking to municipal chiefs and the Canadian Police Association. So
maybe I could just put on the record, Mr. Garrison, that if there are police who presently have any hesitation about bringing forward individuals who are in street gangs who want protection, or witnesses who are the victims of street gangs, our policy remains the same, whether Bill C-51 is passed or not. I mean, obviously we want it passed for other reasons, but I just want to clear up that misapprehension. If there's some administrative restrictions on that that have been made mistakenly, I would only say that they should contact my officials to get that straightened out.
Thank you, Mr. Minister. We welcome that. I believe that misapprehension has been out there, okay. And certainly that the broader definition will help remove that misapprehension, but your statement, I think, is very important. One of the suggestions that was made in the Air India inquiry was that there be some independent review mechanism or some independent evaluation of the witness protection program. And I just would like to hear maybe from your officials whether they feel that would be necessary or whether it's not included in the bill, whether they feel that this can be handled under existing structures.
Well, one of the things that we are doing is separating the investigation of a crime from the administration of the program. And while that all takes place under the RCMP, both the investigation and the administration, we feel that the RCMP are best placed to administer the program. I know there's been some suggestions perhaps of the Department of Justice taking over the administration. Quite frankly, the Department of Justice does not administer programs per se, and that's not a good fit. I have not heard of any complaints about the RCMP administering the program, but I think that it is important to separate the administration of the program from the investigation of the crime so that the legislative criteria are considered on an independent basis. Obviously, they're going to have input from the police who say, we think or don't think that this person is an appropriate candidate. Assistant Commissioner, perhaps?
No, I think you're absolutely correct, Mr. Minister, and we have done that. The program used to, at one point, report through an intermediary. Now the program reports directly to me. Within the respective provinces, we've severed the relationship between the operational side of our business and the witness protection program, and the work done within the provinces reports directly into Ottawa, into offices that report into me, and we are the sole decision makers with regards to the assessment of that protectee, what it will take. And in addition to that, now we have psychological assessments and case management plans that are prepared. So we've really separated, and our program is protectee focused.
All right, we'll move back now to Mr. Gill, please. Go ahead.
Thank you, Mr. Chair, and I also want to thank the Minister and your officials for being here this morning with us on this important topic. Minister, does Bill C-51 respond to recommendations made from the Air India inquiry? Can you talk about that, please?
You know, we look at all of these inquiries to determine how do we best implement the spirit of the recommendation. And we certainly have taken numerous steps right across the board in implementing the Air India inquiry recommendations. So in this respect, the recommendation, I believe, in Air India was an independent program within the Department of Justice. And from a number of reasons, for a number of reasons, it was just felt that that was not the appropriate place to place the program. Department of Justice simply is not suited to this type of a program. And we felt that we could meet the spirit of the Air India inquiry recommendations by having the RCMP administer the program or continue to administer the program, but as the Assistant Commissioner has mentioned, that we separate the operational side from the administrative side so that they can clearly focus on the criteria that the legislation presently has and not be influenced by the operational side in inappropriate or unnecessary way, perhaps is the best way to say it.
Thank you. Another question that I have is, Minister, you may be aware that I've introduced a bill in the House, which is C-394, an act to amend the Criminal Code and National Defense Act, which basically targets individuals who are responsible for recruiting youth, mainly, and also other individuals in criminal organizations, in other words, gangs. It has passed the second reading in the House, and I'm very thankful to have the government's support on this, including the official opposition. But unfortunately, I guess the Liberal Party did not see this being an important initiative. My question to you is, Minister, can you confirm that if a police refer an individual who is part of a youth gang, would RCMP consider that individual?
Well, thank you, and I want to thank you for your initiative in that respect. We think the trying to give the police additional tools to stop the recruitment of especially young people in these gangs is very, very important. And to my knowledge, there is nothing that would prohibit the consideration of an individual into the program simply because of the type of organization he or she is in, or the type of organization that that person is being victimized by. The criteria are spelled out very clearly in the Act, and those are the ones that are utilized. I have never heard of a situation where all of the criteria have been met and somebody says, well, the organization that you're frightened of is not one that we would consider in the context of these deliberations. That simply is not the case. So street gangs are every bit as dangerous as more organized criminal gangs. In fact, the street gangs are often more dangerous because of the tendency to violence and unpredictable violence. So, I'm sure the RCMP know much more about this, but organized crime is more focused on the business of crime, whereas some of these street gangs are in fact much more violent and unpredictable in their activities, and so those individuals I would see as being as vulnerable, if not more vulnerable, than those who traditional organized crime would target.
Thank you for that. In Toronto, Chief Bill Blair has stated that they have seen the fear caused by intimidation and the threat of retaliation in gangs and investigations. Can you describe how the witness protection program and these changes will encourage witnesses with information to come forward?
I think I'll leave that to the Assistant Commissioner, because that's an issue that he has dealt with over the last number of years.
I guess with the changes that are brought forward, if they're entering a provincial regime, with the changes that are brought forward under this new Act, it facilitates the obtaining of documents. It clearly spells out within the Act the protections that are, the criteria that's there, the protections that are afforded to the individuals that are helping us. And quite frankly, I believe that there's everything that's required there to provide proper protection to any witness that wants to enter the program.
It's obviously very encouraging to see that this legislation is standing up for frontline officers. Can you please explain how the amendment in C-51 will benefit those individuals who administer and protect those in the program?
Well, right now the focus of the protection is on the protectees. Of course, as the more successful we are in protecting the actual individual, the more then the focus could be on individuals who are providing that protection and their family. And so it's very important not to disclose information regarding those individuals who provide that protection. So this gives frontline officers another layer of protection by ensuring that there are criminal sanctions in place should that information be improperly released. So as I've indicated from the President of the Canadian Police Association, this is something that they're certainly supportive of and welcome these changes. And I note that the official opposition also indicated that they support that aspect of the bill.
Thank you very much, Mr. Gill, and we'll now move to Mr. Scarpellegio, please, for 7 minutes.
Thank you very much. If gangs are a growing problem, if those in gangs are particularly vulnerable because, as you say, they are violent. Gangs are violent. They do the dirty work of organized crime, I guess, in many situations. And if Mr. Gill's bill is going to target more gang members, I'm not certain that's the case. I'm not certain it will be effective. But if that's the case, if we're putting a greater accent on gangs, if gangs are a growing problem, and if we want to use witness protection to apprehend more gang members, wouldn't you think that a higher rate of admission into the witness protection program would be an indication that crime-fighting strategies are working? In other words, let me phrase it another way. If you expect this legislation and crime-fighting efforts with existing resources to be effective in terms of apprehending more criminals, especially gang members, and you expect the Witness Protection Act to be useful in this battle, wouldn't you expect that there'd be more people admitted over the next few years if you're successful in fighting gang-related activities?
I think we have, I guess what I can say is we have a number of successful investigations that are ongoing, and the number of admissions into the Witness Protection Program fluctuates. It really does, and it fluctuates on if it's an individual gang member, if it's a gang member with a family. So if more people come forward, the admissions could rise, but we've seen it's been relatively steady over the numbers have been relatively steady over the years.
But now we have Mr. Gill's bill, so one would expect that there'd be more apprehensions. Are you budgeting for an increase in admissions?
Are we?
And if not, why not? Given Mr. Gill's bill, and given the minister's or the government's effective crime combating strategies, wouldn't you expect more admissions?
Reference to Mr. Gill's private member's bill?
Yes.
Okay. All right.
Well, let me just. I don't necessarily see that where you have a successful prosecution, that necessarily means that you have a particular witness in need of protection.
But there must be a correlation. There must be a correlation. But anyway, I'll move on to another question. In the report from the RCMP, a confidential report of October 2011, entitled "Enhancing Independence Between Witness Protection and Investigations, Supporting Operations by Widening," I'll put the emphasis on widening, a safer net. It says here on page 13, under the topic changes to enhance independence, in fact, and this is, I guess, the conclusion of some consultations, in fact, it was generally agreed that such independence was positive as long as resource implications arising out of any changes were properly addressed. Now, what does that mean, as long as resource implications are properly addressed? Does that mean as long as more money is available?
No, I think we have to understand that we only have there's only a certain investigational capacity. So there's only a certain number of resources that can undertake investigations, and in turn, a lot of times those witness protections efforts stem from an ongoing investigation. So there's normally only a certain number of admissions into the program. As I shared with the committee, I feel quite strongly that the program right now is properly resourced to run an effective witness protection program, considering the number of cases that come to us each year.
But I believe you. I'm not impugning what you're saying. I believe you. But theoretically, how would we know? Because this information, it would be confidential. It wouldn't be accessible under ATIPs. Would the Police Complaints Commission be allowed to investigate to see if in fact cost is not operationally a criterion?
I guess I'm just trying. I can share that there's over the last year.
I believe you. I believe you.
That I've administered the program. Nobody's been turned away because there wasn't the budget there to do it. So the admissions that came and the people that were admitted.
How do we know? How do we know?
Because the program reports to me, and
Yeah. Okay. Now, but I believe you. I believe you. I'm not impugning what you're saying. But if I may go on to another point, Chair.
2 minutes.
I can tell you, Mr. Scarpellegio, maybe just I can tell you that if there are requests for additional resources in any area, I can tell you I hear about them.
Yeah, but you impose constraints on your budget. So
no, but I've never heard for more requests.
Okay.
No, I'm just
okay. But let's be clear. I take what you say at face value, and I'm sure you're correct. I don't doubt what you're saying. Another of the recommendations in the 2008 committee report, the Air India inquiry report, was that potential candidates for admission to the program be offered the aid of legal counsel during the negotiation of the admission and the signing of the protection contract. Is that foreseen? I didn't see that in the bill.
It's done. We do it as a matter of course in every instance,
Okay,
and we
that's
actually
good.
encourage it.
That's good. We said we were going to make it. You said that the bill, Minister, is going to increase protection against divulgation of information related to the program. Has that been a problem at this point? Have there been?
Well, I think it's we've seen as street gangs or other gangs become aggressive or upset about certain initiatives that they begin to threaten not only the witness but also the broader police, and that is always a concern. And if there's any ways we can stop that activity from spreading, we will take it. And this is, I think, a very good step in that
So
direction.
it's related to gang activity. Yeah. Okay.
Thank you very much, Mr. Scarpellegia. We'll now move back to Madame Dory Lefebvre. 5 minutes.
Merci beaucoup, Monsieur le Président. Merci.
Thank you very much, Mr. Chairman. Thank you, Minister, and Assistant Commissioner Sheen and Mr. Vipsing for being here. It's truly appreciated. First of all, Minister, I'd like to thank you for the clarifications you've made regarding street gangs that could be included in the protection program. Because as my colleague, Mr. Garrison, mentioned, I think there are various stakeholders or actors who had differing views of the matter, and it's quite good that you made those comments. I thank you for them. I'll continue on the issue of street gangs. This is something that I myself have some concerns about, and I'd like to raise them. Perhaps I have a few questions, if you'll allow me. We agree with those who are fighting street gangs, who believe that giving access to the program to people trying to leave gangs, that is an important tool that these people certainly need. It's no secret. But it is already difficult to respect budgetary constraints, given the fact that in municipalities, some street squads, like the Eclipse Squad, in Montreal will be losing funding at the end of March. So what I would like to know is, how do you think you'll be able to implement a bill? Because on the one hand, you'd be implementing a very important bill for the protection of witnesses, but on the other hand, there have been examples of the fight against street gangs in Quebec that have lost their funding. You know, these types of programs have lost their funding because it wasn't recurring funding. I see a bit of a double standard here. I'm really wondering how we're going to be able to implement this type of idea if we cut back on on funding to police services in Quebec, for one, whose mandate it is to fight against street gangs. What do you think of this?
Well, exactly as you've stated, it is the mandate of the Quebec government to take that activity. Policing throughout the province is a responsibility of the provincial and municipal governments. That's the way our Constitution is determined. The federal government did make a one-time only contribution under the police officer recruitment fund. Over 5 years, there was $400 million, but it was made very clear, all the participants understood that that was initial funding over those 5 years, I guess it was, for that purpose. At this time, that is in fact coming to an end. The real issue is, of course, not simply funding police, but ensuring that their work is effective. And their work is effective when the guys who are continually going through the revolving door of the justice system remain in prison. And that has been the focus of our legislation, to ensure that those who deserve to be in prison remain in prison. We will continue in that respect. We will see, I believe, crime drop as a result of that, because it's the same old guys committing the same crimes over and over again. As soon as they're back out in the street, they're committing crimes. The the fact that they are no longer out on the street committing crimes has a tremendous impact on the crime rate. And so we would certainly appreciate your support in some of the other initiatives that we're making in terms of mandatory minimum prison sentences for those who are involved in serious crime. That will help the police more so than $400 million over 5 years. Remember when the NDP said we had to put $19 billion of infrastructure in place to accommodate what C-10 would do. In fact, we know that even my department, who said that there would be 19,000 prisoners by this time, 2013, 3 years ago, up from 14,000. That was my department's estimate. I said, no, that won't happen. At the present time, we have about 15,000 prisoners, so it's up about 1,000 prisoners. And essentially, it's not new people that we're scooping up. We're just keeping the same old guys in prison so they don't get a holiday to go out and victimize more people. It's a very, very simple strategy.
Thank you very much, Mr. Minister. Unfortunately, we're out of time. We're over 5 minutes. We'll now move to Mr. Leaf, please. 5 minutes.
Thank you, Mr. Chair, and Mr. Minister, welcome to the committee again. My first question is for the Assistant Commissioner. Have you, in policing in general, but in this program as well, have you ever experienced an occasion or occasions where witnesses have been reluctant to come forward and testify simply because of their perception of what an ultimate sanction would be? So when a witness says, gee, I'd like to testify, but you know what, at the end of the day, I think person X is just going to get a slap in the wrist, and I'm not willing to put my name out there. I'm not willing to testify. I'm not willing to take the stand. I'm not willing to take those risks if I don't perceive there's going to be an appropriate sanction come down the pipe. Have you ever experienced that in your policing career?
I guess we never, quite frankly, I never had the discussion regarding sanctions. I think the important thing for a witness is always to understand the process. Here's the process. Here's what you're going to go through. To make sure the witness has support throughout the process, and to certainly understand the laws that exist and what they could experience before courts. And that's normally the explanation that's provided.
Okay.
I think, though, if I understand your question, Mr. Leaf, it's the broader policing experience than simply the administration of the program. And,
correct.
And certainly in my experience, not only as a prosecutor, but other roles that I've played in the Attorney General's Department in Manitoba, there's always been that reluctance among individuals who, especially in community areas that are being plagued by gangs, why should they get involved if the same individual is back out on the street on bail very, very shortly, or even upon conviction, they're out very quickly? There is a tendency to view the system as not being proactive enough, and that's certainly something I've heard in the course of my career over and over again. If witnesses can be assured that somebody with a gun is not going to get bail, they are obviously more likely to testify, and that's one of the reasons we made that change, for example, in the reverse onus on bail for those who are carrying illegal firearms, which I think small amendment but very effective over the long term in terms of protecting witnesses and giving witnesses confidence.
And you certainly mentioned in your testimony that that the witness protection program is a tool of last resort because it restricts movement, lifestyle, and associations, and that very few, in respect to witnesses, actually apply for the program. And it's understandable that if a person's movement is restricted and lifestyle is going to be impacted by entering the program, and associations will be limited, that one would also want to consider, that coming forward, I mean, we have parameters in which we would measure whether they would come into the program. I'm certain that witnesses have their own sort of set of parameters in their head. One I would assume being that if they're going to impact their movement, their lifestyle, and their associations for probably the rest of their lives, that they would want to know that there's going to be a meaningful sentence and sanction come along with that. Would that be an accurate statement?
Well, I think all witnesses are different, but that's certainly one of the themes that I've heard over the course of my career. If there is no meaningful sanction, why should they risk themselves or their families in testifying? And again, I'm sure that's something that the investigators are very aware of when they're trying to put a case together. I mean, Mr. Leaf, you've been an RCMP officer. You know what that's all about. How difficult it is in certain communities to get somebody to testify. I know the real problem that we used to have in respect of domestic violence. Horrendous problem where spouses are being abused by the other spouse, and then ultimately the reluctance to testify for a number of reasons. And I think as a society we've moved quite far from the old days back in the 1970s when I was prosecuting as a frontline prosecutor, when so many of the women usually came to court and simply said, I don't remember what happened, or I don't want to go forward. And then the women used to be prosecuted on public mischief charges. So we've come a long way since then. And I think some of the steps that we're taking on this program is just another step in terms of protecting witnesses and understanding how the witness is an integral part of the justice system, which they never used to be. They were sort of an afterthought or just an appendage.
Thank you, Mr. Minister. We'll now move to Mr. Rafferty, please.
Thank you very much, Chair. Thank you very much, Minister and officials, for being here. And I've got 5 minutes now to finally put this whole cost thing to bed, so we don't have to talk about it anymore. So I have some very pointed questions for you. But first of all, let me say why I'm concerned about cost is because we've heard with earlier witnesses and from the government members and from yourselves here today that you're clearly all on the same softball team. The manager has said, whatever you say, doesn't matter what you say, but don't say that it's going to cost us more money. And so that's the impression I've gotten, and so that's why I'm concerned about the cost. So the reality of the numbers are that from the last estimates, we are seeing a reduction in the RCMP budget, about $58 million. And I think the RCMP has said in 2013, 2014, they estimate saving $89.1 million. And so I see money going down, and I know that that's part of what the government's looking at. And I assume also, Assistant Commissioner, that your money is kept in envelopes, or most of it, but perhaps you can beg, borrow, and steal from other programs to make it work. So the question, will the witness protection program be protected from cuts?
Over the past year and coming up, the witness protection program has actually seen an increase in resources.
So then a further question to that, and I don't think we got an adequate answer last time, is that, C-51 will undoubtedly encourage more people to come forward, and that's good, and we're certainly supportive of that. But let us just say that there are maybe not exponential numbers coming forward, but that there is an increase. Will there be an opportunity to ensure, because you will have a certain bar that you don't want to keep moving the bar higher because you don't have any money, and there are people who are worthy of and interested in being in the program. Will you have the opportunity to borrow from other programs, for example, to make sure that all the people who need and require witness protection will be able to get it?
Go ahead.
No, I guess my only answer there is that a lot of the people coming to the witness protection program, some are inadvertent witnesses, but those, in my experience has been, are more rare. So most of them stem from cases or investigations that we have ongoing. So we only have a certain investigational capacity as well. So that's why, as I sit here, there's only a certain amount of investigations that are ongoing which are going to generate a certain amount of potential people coming into the program. That's why the enhancements assist the program, but I don't see a great new influx of people within the program. That's why I'm very comfortable.
Okay. Minister, you...
And just to reiterate, the RCMP has advised me that they have the capacity to manage within its existing budget, which if more funds are needed. That's what they've indicated to me, and I have no reason to doubt them when they say that to me.
Okay. Now, Minister, you said a moment ago that you've, if you hear about funding requests, I mean, if there are funding requests, you hear about them. I'd just like to
happens not only in the House of Commons from you, but it also happens inside the department and inside from the agencies.
Well, my question is specifically about First Nations, and I think we can expect with this bill that perhaps there will be more First Nation activity in terms of witness protection and so on. You know, there are serious problems among First Nations in terms of gangs and so on, and there may be an increased use of that. And so part of the problem is, of course, is that, and I'm sure you've heard this, Minister, many times, is that you know, First Nations police services are woefully underfunded. They do the best they can with the resources they have. And I wonder if you'd like to perhaps make a comment about you know, moving forward over the next couple of years, what you have in mind. I don't expect you to sort of jump the gun, but perhaps you know, there should be increased. The C-51 should be increased usage of that among First Nations. I would expect, just in terms of Northern Ontario, for example.
I don't think that we're going to.
They need more money, Minister.
The First Nations police.
Yes.
Well, they've certainly advised me that they would like to see the federal participation continue in the First Nations policing program. That they've made clear to me in the discussions that I've had with various First Nations communities and with every province in Canada. The Prime Minister has indicated that a decision on that issue will be made shortly. And
the 52%,
Mr. Rafferty,
federal contribution now.
Yeah.
Well,
let him finish. You're over time.
I see the 52% continuing. Well, I can't say anything about that. I'll leave that with the Prime Minister.
Thank you very much, Minister, and thank you, Mr. Rafferty. I just would like to ask one quick question. I think I had permission from our parliamentary secretary on that, but I want to thank you first of all for moving with this C-51. Mr. Norlock's getting ready to ask a question. Mr. Norlock is the only member on this committee that was on the committee in 2008 when the committee issued the report on the review of the witness protection program. And so some of the changes that are happening in this bill are straight out of the good hard work of Mr. Norlock and the committee back then. I would ask one question. I thank you for clarifying on the street gangs, but I think the word that was missing a bit was youth street gangs. And you clarified that. The definition of person that falls under this is any person. Anyone can fall into the witness protection plan. But one of the criteria in the witness protection plan that when you consider whether they would be available is the likelihood of the witness being able to adjust to the program, having regard to the witness's maturity. And I don't know if Deputy Commissioner would just is there difficulty for young people to prove the maturity that they would need in such a program? That was the one question. And if the Minister, or if either of you know, is there any examples, or do you have a rate of recidivism? Because these are two questions that came out of Mr. Norlock's committee report of any recidivism for prior offenders that may be in the program. Are you aware of
You mean repeat people entering into the program because
where they may have been an offender and they were also a witness and they were into the program? Is there any awareness of recidivism later on?
Well, recidivism has the sort of connotation. I want to clear it up that they haven't failed in being in the witness program. It's simply the extent of the involvement of the witness program has no longer been seen necessary. Then these individuals might be involved in another context. They're being perhaps threatened again by the same gang when they're back out onto, into their normal life, and then they're brought back into the program. There's nothing that would prevent that type of recidivism from happening. But the individual has to be appropriate for the program. If they can't offer any protection for the individual within the context of that program, it doesn't really make any sense bringing them into the program if it jeopardizes others in the program, if it jeopardizes investigations, it does everything. There are other ways that the police can take steps to protect them.
Exactly. I mean, there is a responsibility on the witness, and that's the point, right? The witness, if they are a juvenile or if they are a youth, there is a certain responsibility they have in this program.
Yes, everybody within the program, there are definitive responsibilities that are laid out, but I think one of the enhancements from the committees that have come is the addition of the psychologists and the case management plans. The psychologists are there to work with the individuals and develop a case management plan to ensure the individuals entering the program will be successful within the program. That's one of the enhancements, and the plans are so comprehensive. It's very much advancing the program. I'd say we have one of the best in the world.
All right. Thank you very much, Mr. Minister, for appearing here today. We appreciate we have 1 hour and our time is up. In fact, he's stayed a minute or two longer. Mr. Norlock, I apologize. But thank you for your good work on the committee before. And thank you again, Minister.
I want to thank all the committee members for moving this bill ahead as quickly as possible. I think we've been fulsome in our disclosures here, and so I want to thank all the committee members, and I want to specifically thank Mr. Norlock for the work that he did in developing this particular bill because of his prior studies. Thank you.
All right. Thank you. We are adjourned.